She walks it loud like a thunderstorm, debunking myths with style and form. True crime, conspiracies her game. Melissa Jade, remember her name. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Microphone fierce like a roaring lion, unveiling secrets people been hiding. True crime queen of the digital scene, Melissa's got you hooked on her screen. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa J, she's got no shame. Murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa J, she's got no shame. Melissa J, she's got no shame. Melissa J, she's got no shame. From murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa J, she's got no shame. 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 She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa J, she's got no shame.
Hello, everybody. Yes, how are you doing, Gidget? Hi, Fragile Like a Bomb, Claudia, Medusa, Michelle, Seven Lilies. Cicely says, Happy Friday Eve. Yes, happy Friday Eve to everyone. Hi, Jenny Dickman. Hi, Tracy, Deb Lee, Jen Brick, Julie A, Curious Christine, Katrina, Rufian, Micro, Lisa Corinne. Lisa, did you email me and did you end up emailing me when I asked you to and I never got to it? Just tell me yes, I'm a dick. If so, Harley Quinn, Wolfie, Paulinda, Gidget, Search and Rescue Canine Mom. Hi. Kelly, that was crazy what you emailed me. Hi, KV, drive safe. Hi, Sugarfoot, Midnight Lace, Petunia, Harlot, all the way at the top. Hi, Fusili Jamie, Val. Oh, Lisa, I'm sorry. In my defense, busy is an understatement. Yeah. I feel like Gumby. Like, that's the best way I could explain. Hi, Cleaner Lover. Hi, Boho Hobo. I feel like Gumby. And I'm stretching. Like, that's how I feel. But the chaos shall come. Fingers crossed. Yeah, I won't, without detail, can I like say verbally, like without specifics? Hi, Poop Lover. I don't know if Shay's gonna be here tonight, which sucks because I hate doing an Idaho Live without Shay. But I had only gave her a heads up a couple hours ago, and so fingers crossed she'll show up too. Hey, Bogart, thanks for 10 months. Thank you so much. Hi, Natasha. Okay, sounds good. Hi, Amanda. Hi, Crocheting Bammy. Hi, Liz. So, yes, I did. Kelly. Yes, I did. I did see it. I hide nothing but a thing. What's the? I don't remember what I said, Gidget. Sorry, ADHD. I don't remember what I said. What did I mention about insanity? Hi, MK. I've missed you, MK. Thanks, Wolfie. What is a FOIA, Melissa? And please let Forrest know I'm a woman. Yes, attention, Forrest. Wolfie is a female, number one. Number two, a FOIA is a Freedom of Information Act. That is not some internet code. That is not someone being lazy. That is just, if you're in the true crime community, you most likely know what a FOIA is. Freedom of Information Act. Hey, Homer. Yes, Gidget. Hi, King Scarlet. Hello to you, beautiful. And thank you, Wolfie. I'm waiting for Kelly to say if I could share it without the details. I just got called for jury duty, but was notified today that I was dismissed. I was hoping I'd be picked for the Kohberger trial too, but oh no. Listen. Hi, C. Carter. Hi, Tony. Hello, everyone. One, you guys are fabulous. Hello, all you cool cats and kittens. You're all fabulous. Thank you for being here. Two, sorry I got so pissed off last night. Well, I don't think I got pissed off, but like, if anyone thinks I got pissed off, I'm sorry. Hi, Queen of my crew. Oh, okay, Kelly. So what had Kelly had sent me, which, majority of Wade people aren't here right now, but Jesse got a new job, which I won't share the details because that's wrong. But she did get a new job. And you know what, maybe I shouldn't. I don't know. Maybe, all right, you know what, never mind. Never mind. I guess I shouldn't even say what the position is and stuff. Hi, Bree. Hi, Luann. Hi, Morale. Yeah, oh, look, a squirrel. I'm honestly, I'm just at a point where someone is always going to be triggered. Someone's always going to be triggered, and I'm tired of it. And I saw a comment that really explained it perfectly, and I don't remember who it was, and I'm paraphrasing what it stated, but it said basically the expectation for it's on you when you're going to watch content to choose wisely what you're going to watch and protect yourself if you can't handle something. It is not on me to conform my entire channel around each individual person's boundaries. Something along the lines of that, and that's perfect. And thank you, Wolfie. Yell at me, whatever you want. Hi, Peach. Oh my God, it's been so long. Hello. Hi, Lisa Marie. She's working as a manager. I know. Well, that's how I felt. Well, honestly, I think I got more offended that if you I really, even though I know I use my sense of humor for me is my coping mechanism. I will be the one who uses my sense of humor in a really fucked up situation in my own life. So I don't like when people may judge me because I might have a specific tone or how are you laughing? I laugh when I get uncomfortable too. Number one. Number two, everybody knows. What do you think? I read all these emails before I go live? I literally don't have time for anything right now. So how am I supposed to give a trigger warning when I didn't even know it was about to happen? 3, if anyone thinks I read Raquel's email last night and thought it was based in reality, I think that's more of a you problem. Raquel has accused me of ingesting mosquitoes every day. I know that you guys don't know that, but remember when I said there is a bunch of communications that I don't share, right? Because I'm not trying to exploit someone who's clearly mentally ill. She tells me that I ingest mosquitoes on a daily basis. Don't ask why. It doesn't matter why. She's also stated that I'm going to get killed by aliens. She also said that she saw a ground level shooting star. She also says that an entity is who leaves voicemails, not her. So if you for 1 second thought I was reading that email last night about this cat and I thought it was based in reality, I don't know what to say to you. Now, if it was someone else who was describing in detail this video of this cat in a microwave, would I be more likely to believe, oh, wow, this is fucked up? Yeah, but I'm dealing with Raquel, and there is absolutely 0 out of every time where she's incorporating something in reality into the emails. I kid you not, Pointer Lover. I think I showed it to Natasha. She says I eat, and no, not eat. I ingest mosquitoes daily. So my point is that I understand that it could be triggering for some. I understand that it could be upsetting, but it's not my fault. Number one. Number two, I'm not going to just stop mid-email and jump over it. Number three, if it's too much for you, click off. But you can't expect me to be like, oh, wait, for one person, oh, it's too upsetting for you, let me get off of it. No. And you know what? Things like this is happening anyway. And I'm tired of tiptoeing. I'm just tired of it. I'm not doing it. Hi, Neat Noodle. Hi, Pipsqueak. Yo, listen, thank you, Karen Petty. Yeah, what about, yeah. I should have gotten the trigger warning. Okay. And Harlot, it's a new update now that they're doing like a beta thing. Yeah, it's true crime. Listen, we discuss very heavy things, but my point is that it was Raquel. It was Raquel. Out of everything that you've heard me read, all of a sudden you thought the cat was true? You thought that was based in reality? Like, she explains to you that she speaks in third person when speaking to Wade because she doesn't want to speak directly to the entity. But I digress. It doesn't matter. Point is that get over it. Like, I had people in the comments saying, the giddy in your voice, I'm unsubscribing. Okay, go ahead. I'm not going to chase you. I don't want to say I don't care, because specifically would I care with a lot of you? Of course I would, but I'm not going to bend over backwards. I can't do it, period. And I don't like being shamed because someone's tolerance for things may differ from someone else, or I may giggle or something. I giggle when I'm uncomfortable because it's better than crying. So get over it. Harlot. No, I think they did like, it's like a beta thing. I don't know. But it's so small you can't even read it. They gotta make it bigger. Aw, you like my chaos. Neanderthal. I love that freak fam. All right. Hi, Tess. Yeah, I did not listen. What I imagined, what I read is of the possibility that, yes, Raquel may have watched a video. Okay. And yes, it may have included in some way or fashion, maybe a cat and maybe a microwave, not together. It didn't even get into those types of details, but Raquel's mind works very uniquely, and she explains over and over that these are her interpretations of events. These are her interpretation of what she saw. So, like, God, you guys, like, not you guys, but like some people were acting like this is a duck. Like, I was going over the don't fuck with cats, fucking Luca Magnotta. Like, I don't know what you want. Hi, Trulia Beach. And also, I'm like one of the biggest animals. Like, I don't trust cats. I've openly said that from the beginning, but I love animals and I would never be giddy talking about animal cruelty. But again, she says I eat mosquitoes. Is that true? No. Okay. So let's just kind of like chill out a little bit. because she's sick, Debly, like that's the best way I could explain it. I don't hold her, and I don't want to say I don't hold her accountable. I do. What she says is fucked up. But it is very obvious she has a mental illness. Not in a mean way, but it's very obvious. I'm not like, my expectations are already going to be set at a certain level. And if it's beyond her control, I don't know. I'm not a professional. I don't know. But it's obvious what's going on here, right? I wouldn't expect Lieutenant Dan to be able to get up and do the Cotton Eye fucking Joe, right? My expectations are set lower because he ain't got no legs. You see what I'm saying? Like, chill out a bit. You will be coming out wrong. Kevin's all right. I just don't trust cats. All right. Either way, we're getting very far out. Thank you all for being here. Please take a second, hit the thumbs up. If you haven't, fingers crossed, Shay will do a pop-up. My bad. I haven't been pre-planning lives in advance, which sucks, but I really hope that she shows. But let's pull up our missing child for the live stream, and then let's get into something that's making me very nervous. It is and it isn't. We'll discuss it. So this is You Ain't Got No Legs. Okay, so this is Diana Alvarado Argueta. She has been missing since March 21st, 2025 out of Rahway, New Jersey. She is 14 years old. If you or anyone you know has information on her whereabouts, please contact the Rahway Police Department in Jersey at 1-732-827-2200. I don't hate cats. Let me be clear. I don't hate cats. I just don't trust cats. There's a difference. But I'm still the biggest animal lover, and I would never be okay with harming any animal. Are you queen of my crew? So yeah, Jesse's working as an office manager at a dental office. I won't say where. But honestly, no hate to that. I have nothing bad to say about that. Anybody, working and getting a legitimate income, that's not a bad thing, So even though it's like, oh, look, she popped up, it's a good thing. I'd rather, I can't say anything bad about that. Hey, Jack. MJ, can you reveal just your funniest moment from high school? Be explicit if needed. No. Sorry. And it's lovely seeing you. No. I've already overshared on the internet in the past, and I've learned my lesson. So, no, I'm not going to, because I'll blabbermouth. I know, it was quick. Poor Linda says, what are your thoughts on who leaked the information? That is exactly what we're going to get into, poor Linda. So, the last time we were live, we went over the last hearing, and I knew this was going to come because the state, the defense has been really looking for any opportunity which, at least for the death penalty, I understand, to get that thrown off or whatever mitigating circumstance. Okay, whatever. But to get the trial pushed, and we first saw that, I don't remember what specific hearing it was. I think it was a motion in limine. It was the motions in limine. And Hippler had to come to Anna and was like, listen, when we last touched base, you told me you were good. Everything was on the ball as far as arriving to this trial date. Now you're coming before me and you're saying you haven't even gotten through half of the discovery. And Anne's like, right, well, that's true. But she had since taken on also another death penalty case, which why would you take on and do 2 death penalty cases simultaneously if you can't even finish one? Well, I took that on at the time where I still believed, whatever. Point is, it was very obvious that she was trying to get this trial pushed. So then we had this Dateline episode, right? Oh, I'd love a bagel right now. No. We had this Dateline episode, and I said it 2 episodes ago. Did I enjoy having the information? Absolutely. Do I think it was right or fair for information to come out right before trial? No, I don't. And it seems to me like, why so quickly? Why so quickly right before we're about to get all the answers? I don't know. But point is that I wasn't against receiving the information, but do I think it was right for that information to come out? No, I don't think that was. Now, we have to remember that this case in particular has a super strict gag order. That isn't usually the circumstances. So, Judge Hibbler was not happy. And Judge Hibbler said he's going to assign a special prosecutor, which is very serious. Why did it remove his super chat? Did you do it, Wolfie? Who removed Jack's super chat? You're going to get a timeout. So, no, Debley, and I'll explain why. Wow, Wolfie. Wow. Everyone shame Wolfie. Wow, how dare you delete my support? Well, I missed it, Natasha, so let me shame her in peace. Shame. Very shameful. Ooh, yum, Medusa. I'm hungry. That sounds delicious. Okay. Judge Hibbler said he's going to assign a special prosecutor to this. Okay? And they're going to look into the source of this leak. Now, I'll talk to you in a minute about what my opinion is. With that to the side, where is the concern as far as this impacting Bryan Kohberger's trial? Okay? And it didn't seem like at that point Judge Hibbler even indicated that he had any concern of this impacting the trial date versus concern that, hey, this isn't right. We have a leak of information and I want to look into it. It doesn't, Tess. It doesn't. Dateline's not going to get in trouble. So Dateline doesn't have to share their sources, and it's not on Dateline if someone else broke the gag order. But Anne is, and we saw it hit a motion to continue, and it was either going to be about a hearing, maybe the alternate perpetrator, or the trial itself. And long and behold, it's the trial itself. So the argument's going to be, and we're going to go over it. Well, now that Dateline episode aired, and it's reached a whole new network of people, and it had very graphic details that should not have been released. Okay. And Judge Hippler is assigning a special prosecutor and will be looking into the potential source of the leak. But if the jury had already been picked, absolutely understand there is now a cause for concern. But they haven't gone through the jury selection process. And so we are still in the same exact boat that we were in before the Dateline episode. They are still going to be looking for 12 jurors, 20 total, 20 jurors who are not familiar with the case. Other than that, this doesn't affect Kohberger's trial. There is nothing Anne needs to do. It is not her job to look into a leak. There's a special prosecutor. This is going to be a parallel thing on its own. It could be because if the jury was picked already, Deb Lee, and let's say they went through the extensive process of, hey, do you, like, let's use, for example, you, Deb, right? They went through a process where the prosecution got to ask questions to you, defense got to ask questions to you. They both agreed, yep, Deb Lee isn't familiar, never heard Bryan's name before, we pick her. And then the Dateline episode comes out and you watch the Dateline episode, or you even heard a little bit about the Dateline episode. Well, now that's an issue because when they had chosen you, you hadn't known anything. You see what I'm saying? So we're not at that point. And thank you so much, Mallory. We're not there. The jury pool hasn't been picked. And thank you so much. I'm so sick of AT throwing spaghetti at the wall and stall tactics. The doc happened. They will still find a jury, just like every high-profile case. Boo-hoo, poor PK. Poor BK. I care about Maddie, Kaylee, Ethan, and Xana. Listen, two things can be true at the same time, right? We could absolutely want justice for these victims while at the same time making sure Bryan has his fair trial, because he absolutely has a right to this fair trial. But it really doesn't impact it at all. Like, that's just the honest truth. It does not impact it at all. Thank you, Samus. Someone delete that. Hello, Colorado Ped Patrol. This is Idaho 4 case discussion. Yes, absolutely. Yep. And no, the truth, yeah, she won't ever. And I think he's going to. King Scarlet. Listen, you guys have to remember. Oh, and I wanted to get this link for the mods to share. The families had to raise money and really adjust their lives. You have to remember, this is at least 3 months. It's going to be a 3-month trial. It took a lot of preparation and money, hi Samantha, to book their Airbnbs, make the arrangements with work, make the arrangements with potential childcare, and get up, and they've had this planned. You see what I'm saying? 4 families. I do not see, listen, Judge Hippler has been on it. You're avocadorable, Samantha. Congratulations. Hippler has been on it. I do not think for 1 second he is going to agree to a continuance, which would mean, hey, everything as far as that was been booked for the families, how far out in advance, everything that's been pre-planned as far as their jobs. I do not. Because again, how does this actually affect? Why does the defense need more time? Are they going to say, well, they want more time for things to cool down and it not to be such a hype? No, because the same jurors that you'd be picking wouldn't know anyway. And they're allowed to know basics, like on the at Vallo's trial. There were some jurors who his wife was very much following Lori's case, and he knew just like basics. So they're allowed to, it's not like I've never heard of him at all, but it's just a level of how much. But it doesn't impact the defense at all. You have not picked the jurors, so there should be no reason for this to be continued. It's just an opportunity. But with that being said, I think it was sloppy. And the question is, who leaked this? I think that this was, in my opinion, hi, misbehaving. Oh, is it really? I didn't realize that. In my opinion, this was not a current leak. I think this had probably trickled out some information that had already been around with additional information that had come out along the way. And someone made a choice to give that information. But then I think with Dateline, they say a source close to the investigation. Maybe it was someone, a former, I don't know. I really don't know. Well, that's another tactic. Is it possible that it was an intentional leak? Let's consider all things here for this exact reason. Was it a Hail Mary? Hi, Sugarfoot. Let's see what we have. So we have, oh, you know what? Let me just see how quick this is. Okay, these are the two quick ones, and then I'll do the motion to continue. So this was the first, which is the defendant's motion for leave to exceed the page limit. So this is just Bryan Kohberger's team hereby request the court for an order to allow the defense to exceed the page limit for their motion to continue and their ex parte supplement to the motion to continue. Okay. And then we have an order granting it, which just says, yes, you can. So this is the main one. So buckle up, guys. We have the defendant's motion to continue, and we have a 40-page motion. You guys ready? So this is what Bryan Kohberger's defense team, which again, Ann Taylor, Alyssa Masseth, Bika Barlow. Oh, why isn't he on it? Oh, Jay Logston. There we go. And Jay Logston. So we have the motion to continue. So what is Ann doing? Ann is asking, hey, I need this child to be pushed. Right, Harlot, right. Lemons float, but limes sink. Thanks, Seamus. You're fine. Hi, Miriam. Hi, Lacey. Yeah, it could have been Lacey. It could have been with then also someone else too. Could have been maybe not just one person. It could have been. Yeah, honestly, Lacey, I think that's very much in the box as a possibility. Hi, Mallory. So let's get into this. You guys ready? So it says, come now, Bryan C. Kohberger, by and through his attorneys of record, hereby respectfully submits the following motion to continue. Due to the substantial amount of trial investigation and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense, any conviction and sentencing resulting from a capital trial beginning in August 2025 will be unconstitutionally imposed and therefore vulnerable to reversal on direct or collateral review. In making this motion, Mr. Kohberger relies on his right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, his right to counsel, his right to present a defense, his right to confront witnesses, his right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Idaho State Constitution. So we have a table of contents, which whatever. So here is our argument, which again, I do not see. Sorry, that threw me off. I do not see, hi, Carrie, Judge Hippler approving this, because at the end of the day, an entire investigation will be done regarding the potential leak. Special prosecutor, that is his whole sole job. That'll be its own case. It does not impact it could lessen the potential jury pool, but that's it. So here's her argument. 1, this court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time to review discovery and prepare for the complex merits and sentencing phases unique to death penalty cases. Yet if that was the case, Miss Ann Taylor, why'd you take on a whole nother death penalty case? Asking for a friend. So this court has an obligation to enforce the constitutional rights of all persons, including prisoners. As detailed in this motion, moving forward with a capital trial in August will infringe upon Mr. Kohberger's constitutional rights, as counsel requires more time to review discovery, complete investigations, and prepare for trial. When considering this request for a continuance, the court must weigh the issues against the heightened need for reliability in death penalty cases. This elevated standard is essential because execution is the most irreversible and profound penalty. Indeed, death is different. Ford versus Wainwright. When the state seeks the death penalty, it imposes an extraordinary burden upon the court itself and defense counsel to ensure the fairness, accuracy, and reliability of the trial and any subsequent sentencing proceeding. With a defendant's life stake, the trial court must be particularly sensitive to ensure that every safeguard is observed and must take extraordinary measures to ensure that a death sentence is reliably imposed rather than imposed out of whim, passion, prejudice, or mistake. So Justice O'Connor's concurrence in Thompson's versus Oklahoma reinforces the idea that trial courts must apply heightened scrutiny to decisions potentially leading to the death sentence. So because proceeding to a capital trial prematurely is a decision that may lead to the erroneous imposition of the ultimate sanction, this court must consider and assess this motion under a heightened standard of due process. All right, she's coming in strong. But I feel like she tried, and hi, AU Mom, she tried wiggling this in two hearings ago, and Judge Hipper was like, nah, how about, and if you guys remember, he offered, I'll give you paralegals, I'll give you, clerk, whatever you need to build your team to get through this discovery. And wasn't happy about that because, okay, well, you could give me 20 people. They won't know what I'm looking for. So now she got her opportunity. Hey, Pickle, she got her opportunity and she's going for it. I don't blame her for going for it. But I don't see Hippler at this stage approving it. But what I will say, when defense requests a continuance, especially the first one, the courts usually will be more likely to approve it because down the line during appeals, it could come up. Does that make sense? And that's what she even mentioned, like, oh, if you jump the gun here, it can be overturned. It could be Pickle. Hi, Jenna Gypsy. So that's my only concern, is that there would be that factor of, well, if I don't at least approve one continuance, once it's requested, that down the line it could be used during appeals. So it says, 2, Mr. Kohberger has myriad constitutional rights during these proceedings, all of which are dependent on counsel having the time and resources to prepare for a capital trial in accordance with established professional norms. A, in capital cases, the right to effective assistance of counsel and a complete defense are amplified. So the Sixth Amendment entitles Kohberger to the effective assistance of counsel at both the merits and penalty phases of this capital case. Additionally, and concomitantly, as part of this Sixth Amendment guarantee, as well as his right to due process as protected by the 14th Amendment, Mr. Kohberger is entitled to a sufficient amount of time to allow counsel to adequately prepare for trial and sentencing. So case law states a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. The Supreme Court has recognized that depriving a person of counsel during the period prior to trial may be more damaging than the denial of counsel during the trial itself. Ooh, that's a big jump, man. In a capital case, counsel must meet specific professional obligations to constitutionally be effective. The ABA guidelines outline the professional expectations and obligations for counsel in death penalty cases. These guidelines are not merely aspirational, they represent the current consensus of what is necessary for effective representation in capital cases. Exactly, it wouldn't do anything, Samantha. The Supreme Court has consistently referred to the ABA guidelines to determine the prevailing professional norms for counsel's performance. They cite case law. So the Ninth Circuit, which would review any death sentence out of Idaho state courts, has also repeatedly relied on the ABA guidelines and expressly recognized the guidelines as a proper measure of the adequacy of an attorney's investigation. So the ABA is the American Bar Association, and their standards, are evidence of those norms and guides to determining what is reasonable. The Ninth Circuit is not an anomaly. More than 700 capital case opinions cite the ABA guidelines. In addition to the effective assistance of counsel, Kohberger has the right to a meaningful opportunity to present a complete defense. The 14th Amendment, criminal prosecutions must comport with prevailing notions of fundamental fairness. We have long interpreted this standard of fairness to require that criminal defendants be afforded a meaningful opportunity to present a complete defense. This right has a number of sources, including the Due Process Clause of the 14th Amendment, as well as the Compulsory Process and Confrontation Clauses of the 6th Amendment. MK, thank you, sir. Woo, woo. Thank you so much. I'm looking for my... Wow, thank you. Congratulations. Right. That's exactly what it is. Just because she's not prepared doesn't mean she wasn't given enough time, and it went from, Oh, you know what? I actually went through those tips and I may happen to have found something that may point to an alternative perpetrator. And then all of a sudden at the next hearing, yeah, no, I have the information regarding the alternative perpetrator. And you could tell it was just like the alibi, because Hippler's like, you got to give me more. Like, this is not specific whatsoever. November 2022, Samantha. November 13th, 2022. Kohberger was the end of December, so let's just say January 2023. Let's just say January 2023. But yes, they didn't get all the discovery at once, but it came in at the same rate that it came in for the state. So this right takes on special significance in capital cases. The right to present a meaningful defense must take precedent over any countervailing state evidentiary rules or other procedures that might be acceptable in the context of non-capital criminal cases. So Mr. Kohberger B is also entitled to an individualized sentencing determination, a constitutional right that is uniquely reserved for defendants facing the death penalty. Because the prosecution is seeking to execute him, Mr. Kohberger has also additional constitutional rights in the proceeding. Yep, she did, Harlot. Yes, she did. Sloppy mistake. The Eighth Amendment requires that a capital sentencing proceeding permit individualized consideration of the defendant and the circumstances of the offense. We got case law. So the U.S. Supreme Court has repeatedly emphasized that in a capital case, a jury must be given the opportunity to consider all evidence that may weigh against a death sentence for any particular offender. This evidence includes anything at all from the defendant's life history and cannot be limited. So when a jury is denied relevant mitigating evidence, and relevant mitigating evidence is evidence which tends to logically prove or disprove some fact or circumstance which a fact finder could reasonably deem to have mitigating value. So when a jury is denied relevant mitigating evidence, either because counsel independently fails to conduct a complete investigation, or because the court denies defense counsel adequate time or resources to conduct such an investigation, the defendant's rights under the 6th, 8th, and 14th Amendments of the U.S. Constitution, as well as the corollary guarantees in the Idaho Constitution, are violated, and any resulting death sentence cannot stand. Thus, individualized sentencing requires the presentation of mitigation evidence that is properly investigated, documented, and presented with the help of appropriate experts. As detailed further below, this process is a comprehensive, time-consuming, and expensive undertaking, but it is also what our Constitution demands when the government seeks to extinguish human life. Exactly, Samantha. So C, the right to qualified expert assistance as part of the guarantees to effective assistance of counsel and an individualized sentencing proceeding. So basically, yeah, she does, Natasha. And she's like, basically, if you move forward with this, I can't be effective counsel for him. And that's just not fair for him. So it says, in line with the heightened protections afforded to capital defendants and stemming from both the rights to a meaningful opportunity to present a complete defense, capital defendants are entitled to necessary expert assistance. Indeed, expert assistance is needed in all homicide cases, given that investigating a homicide is uniquely complex and often involves evidence of many different types. Analyzing and interpreting such evidence is impossible without consulting experts, whether pathologists, serologists, microanalysts, DNA analysts, ballistic specialists, translators, or others. ABA guidelines. However, in a case where the prosecution elects to seek the death penalty, the right to access competent expert assistance is particularly important, given that the prosecution and the defense rely more extensively on experts in death penalty cases than in other types of criminal cases. On federal death penalty cases, on Defender Services Judicial Conference of the U.S., it says, because prosecutors rely extensively on experts in death penalty cases, capital defendants cannot, quote, present their claims fairly within the adversary system if they have not also obtained competent expert assistance. Beyond the frequently complex merit phase issues, conducting an adequate investigation into sentencing phase issues in a capital case almost always requires the assistance of multiple experts. So a state must provide a mental health professional capable of conducting an appropriate examination and assisting in evaluation, preparation, and presentation of the defense. Noting that because mental health issues pervade capital cases, a psychologist or the other mental health expert may well be needed as a member of the defense team. An additional expert assistance specific to the case will almost always be necessary for an effective defense. As discussed further below, defense counsel cannot know the full range of experts that may be necessary until after the extensive social history investigation has been completed. Both the identification of a mental health professional's necessary area of expertise and accuracy of the expert's diagnoses is dependent on having accurate and comprehensive social history information. What have you been doing? Sorry, let me pause that for a second. What have you been doing? So you just pop up and all of a sudden get an ASD diagnosis on the most mundane level. And now, well, I need to go do this whole extensive history, comprehensive history. What have you been doing? Hi, Hope. Right, Heidi. I just like, you've had the time. Don't say you haven't had the time. If you haven't been looking into his social history by now, I don't know what you've been doing. Well, I don't think he'll have so much a clapback because now the Dateline did open the door to make it easier for her, but I am concerned that he knows denying a continuance could potentially be an issue if it got to the appeal process. So 3 is the counsel's professional and ethical obligations in a capital case. A, counsel's duty to provide effective assistance of counsel in accordance with the prevailing professional norms. In order to effectuate Mr. Kohberger's constitutional rights, as described above, counsel must at least meet the minimum professional obligations for counsel on a capital case as outlined in the ABA guidelines. The ABA guidelines require, quote, high quality legal representation for all persons facing the impossible imposition or execution of a death sentence by any jurisdiction. Among many other things, the ABA guidelines recognize that, quote, every task ordinarily performed in the representation of a criminal defendant is more difficult and time-consuming when the defendant is facing execution due to the extraordinary and irrevocable, why can't I say that word? Irrevocable? I feel like I get stuck every time on that one. I don't know why. Irrevocable nature of the penalty. At every stage of the proceedings, counsel must make extraordinary efforts on behalf of the accused. the extraordinary responsibilities and commitment required of counsel in death penalty cases. So it's so funny because, like, I guess unless you're always like reading out loud, reading in your head is one thing. When you're reading out loud, there's just some random words that your brain kind of like, at least mine, it's like, wait a second, what, and it takes a second for me to be, okay, hold on. I don't know why my brain just won't naturally process that word easily. So B, we have the minimum requirements counsel must meet in investigating for the merits phase of a capital case. With respect to investigation for the merits phase, the ABA guidelines are clear that counsel must thoroughly investigate and challenge every minute piece of the evidence that state purports to have. To assume the accuracy of whatever information the client may initially offer or the prosecutor may choose or be compelled to disclose is to render ineffective assistance of counsel. The defense lawyer's obligations includes not only finding, interviewing, and scrutinizing the backgrounds of potential prosecution witnesses, but also searching for any other potential witnesses who might challenge the prosecution's version of events and subjecting all forensic evidence to rigorous independent scrutiny. In addition to a complete investigation of every piece of the state's case, counsel is then responsible for identifying and considering all legal claims potentially available, even if those claims have consistently lost in that jurisdiction. This is necessary because counsel in a capital case has a duty to preserve, quote, any and all conceivable errors for each stage of appellate and post-conviction review. Non-preservation of an issue at the trial level may result in waiver and ultimately in a defendant's execution, even if reversible error occurred. This obligation places a significantly higher burden on defense counsel than in a non-capital case. In an ordinary criminal case, counsel could strategically forego some aspects of the exhaustive investigation outlined step by step in the ABA guidelines and would not be required to preserve every possible legal error for potential review. Furthermore, there would be significantly fewer legal issues to address because the unique issues related to capital sentencing would be irrelevant. C, counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, and compile all of this information into a cohesive narrative for the sentencing phase. Your job. Oh, you're right, Harlot. It doesn't. Sorry, but basically, you're outlining your job. Yes, we know what your job is for capital cases. Sorry, but this is all you're doing, is you're going through how capital punishment differs. Yes, we're aware. So, what a constitutionally adequate investigation entails. A constitutionally adequate investigation for the sentencing phase of a capital case requires a comprehensive investigation into the client's entire life history in order to present a complete picture of the client's mitigating life circumstances to the jury. Because the sentencer in a capital case must consider in mitigation anything in the life of the defendant which might mitigate against the appropriateness of the death penalty for the defendant, penalty phase preparation requires extensive and generally unparalleled investigation into personal and family history. The life history investigation is so central to death penalty cases that there is a supplementary set of guidelines specifically outlining counsel's responsibility in this piece of case preparation. The defense must conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, record, and any circumstances of the offense or other factors which may provide a basis for a sentence less than death in order to meet their constitutional obligations. Compiling a comprehensive life history for a capital sentencing phase requires two primary responsibilities. which are dependent upon each other, as further explained below. These responsibilities are 1. Collecting and analyzing records from the client and the client's family life history, and 2. Interviewing individuals who have touched the client's life or who may be able to shed light on circumstances shaping the client's life. It is well established that life history records that must be collected include, but are not limited to, all records that may be in existence and which bear on any of the following subjects: medical history, complete prenatal, pediatric, and adult health information, exposure to harmful substances in utero and in the environment, substance abuse history, mental health history, history of maltreatment and neglect, trauma history, educational history, employment and training history, military experience, multi-generational family history, genetic disorders, and vulnerabilities, as well as multi-generational patterns of behavior. Multi-generational patterns of behavior. Okay. Prior adult and juvenile correctional experience, religious, gender, sexual orientation, ethnic, racial, cultural, and community influences, socioeconomic, historical, and political factors. Contemporaneous records are intrinsically credible and may document events which the client and other family members were too young to remember, too impaired to understand and record in memory, too traumatized, ashamed, or biased to articulate, or events which the client knows nothing about, but which may document significant events or conditions in the client's life. In addition to collecting and analyzing those life history records, the defense team must identify, locate, and interview life history witnesses in a culturally competent manner in order to produce confident, relevant, and reliable information. Lay witnesses that must be interviewed include people such as A. the client's family, extending 3 generations back, and those familiar with the client. B. the client's friends, teachers, classmates, co-workers, employers, and those who served in the military with the client, as well as others who are familiar with the client's early and current development and functioning, medical history, environmental history, mental health history, educational history, employment, training history, military experience, religious, racial, culture experience, and influences upon the client or the client's family. C. social service and treatment providers to the client and the client's family members, including doctors, nurses, other medical staff, social workers, and housing or welfare officials. D. witnesses familiar with the client's prior juvenile and criminal justice and correctional experiences. E. former and current neighbors of the client and the client's family, community members, and other familiar with the neighborhoods in which the client lived, including the type of housing, economic status of the community, availability of employment, and the prevalence of violence. F. witnesses who can testify about the applicable alternative to a death sentence and or the conditions under which the alternative sentence would be served. G. witnesses who can testify about the adverse impact of the client's execution on the client's family and loved ones. It is vital that the interviewer conduct these interviews in person, face-to-face, and one-on-one, and that multiple interviews be conducted to establish trust and rapport in order to elicit sensitive information. As the mitigation investigation develops, red flags will become apparent, indications that a particular mitigating circumstance or theme may be present in the defendant's life history. When counsel discovers a red flag, it cannot be ignored, as to do so would be to abandon the investigation at an unreasonable juncture. The development of the mitigation investigation, including the identification of and subsequent follow-up of red flags, is dependent on both the life history records and interviews of witnesses. These two-part function together in order to produce a reliable life history narrative. For example, do I need to go through all of these? I feel like I don't need to go through all the examples because that's really just for this. I get the point if you guys get the point. So, adding to the complexity, it has been long recognized that a competent mitigation investigation must include the family history going back at least 3 generations and must document genetic history, patterns, and effects of familial medical conditions. Because it is well established that many major psychotic illnesses have strong genetic components, the existence of mental illnesses or related conditions in the family tree is vital information for mental health experts evaluating the client, and the absence of such can lead to incorrect diagnoses. So, 2, a full investigation is likely to lead to discovery of numerous mitigating factors that would not be readily apparent from a cursory investigation. Shut up, Samantha. Oh, I love that too, Robin. Hey, FOS. Yeah, Pickle. I wish I had a snack. I don't know what kind of snack, but like a snack. Either way, let's go. A full investigation is likely to lead to discovery of numerous mitigating factors that would not be readily apparent from a cursory investigation. Records, interviews, and other psychosocial research collected during the mitigation investigation process may reveal the following types of information, all of which has been considered mitigating in the modern era of capital punishment: fetal and birth trauma, problems in early physical, emotional, mental, and social development, physical illnesses and impairments, evidence of early or adolescent signs of mental illness or deficiencies, including mental retardation, pervasive development disorders, and major mental illnesses, educational history, including when and where the client attended school, patterns of social behavior, including acting out in anxiety and/or tendencies towards isolation, the history, nature, and extent of psychological, physical, and sexual abuse, a history and course of self-medicating behaviors and subsequent drug and alcohol dependence, the nature of relationships with parents, nuclear family, and extended family, residential history, including housing projects, foster homes, juvenile settings, pattern of evictions, institutional settings, and community violence, presence or absence of social and community support systems, nature and extent of poverty, the number and nature of traumatic events, employment history, juvenile and adult criminal history, military history, patterns of all significant relationships and any indications of attachment disorders, physical and mental health, substance abuse, social education, employment history of parents, caretakers, siblings, and other significant individuals. Water. Blood. Three, mere identification of mitigating information is not the conclusion of the investigation. Though it requires many hundreds or thousands of hours to complete the interviews and records collection in a constitutionally adequate manner, the mere identification of mitigation themes, such as those listed above, is not the conclusion of the investigation. Counsel must then analyze each theme in accordance with available empirical and social science, usually with the help of experts, and must decipher how each mitigating theme played a role in the client's life. For example, childhood poverty is a common mitigating theme in capital cases. It is incumbent on the defense team, therefore, to investigate beyond the mere service level identification of mitigation factors. The contextualization and integration of mitigating life history information is an essential part of the capital sentencing decision, because jurors ultimately are looking for an answer as to the question, why? In sum, compiling a life history is not merely a checklist of tasks. It is a complex and rich endeavor that focuses on a person's identity and goes to the heart of the human experience. D, the alleged aggravating... I'm starting. This is why I need Shay here so we could go off and on. D, the alleged aggravating circumstances of this crime heighten counsel's obligation to conduct a full and complete investigation and Oh, it's too much talking. I need a break. And prepare a presentation that can withstand adversarial testing. Okay, hold on. Let me just really take a break, or else I'm going to start tripping over my words all the time. I don't know what spicy fries are, Natasha, but hot fries are spicy. That sounds good. Woo! I need like a fucking Ricola or something. All right. It should be noted that an integrated, comprehensive life history is not a luxury to be afforded to only some capital defendants, nor is it offered as an excuse that stands no chance in the face of an aggravated crime. Rather, it is a vehicle that confronts and challenges the stereotypes of the natural-born killer, offering instead an examination of the structure of the lives of those who commit capital violence. Hi, Solo Angel Mom. Well, what? Well, to be fair, if I'm reading, guys, I'm not on this screen. Like, I can't read all of these law words and then at the same time chat. So if I miss you, I apologize. Rather, it is a vehicle that confronts and challenges the stereotypes of the natural-born killer, offering instead an examination of the structure of the lives of those who commit capital violence. Moreover, there are many examples of the capital cases in which the presentation of a comprehensive life history and mitigating circumstances overcame aggravated crimes, including cases with multiple victims. Indeed, juries have rejected the death penalty in at least 400 cases involving multiple victims, demonstrating that the outcome of this case, even in the event of conviction, is anything but a foregone conclusion. A death sentence is not a guaranteed outcome upon conviction of an aggravated capital murder case. And in a case where the allegations are sensational in nature and have been the subject of intense media and public scrutiny, a comprehensive and accurate life history presentation is even more crucial to the constitutional imperative of an individualized sentencing determination to ensure the aggravated nature of the crime and the public outcry does not overcome the jury's ability to weigh both options. Thus, capital defense team have a complex and time-consuming job in identifying and interviewing life history witnesses, collecting numerous life history records from the client and his family, and then analyzing and contextualizing all of the information into a cohesive narrative for the jury should the case proceed to the sentencing phase. And as discussed in the following section, it is only after the mitigation investigation nears completion that counsel can identify all of the behavioral, cultural, scientific, and mental health experts that may be necessary to develop the mitigation presentation and allow for individualized sentencing as required by the U.S. Constitution. It's too much reading at once. Okay. E. Counsel cannot identify all necessary experts without completing the comprehensive life history investigation. In addition to frequently complex merit phase issues that are likely to require expert assistance, adequate investigation into sentencing phase issues almost always require the assistance of multiple experts. In particular, the defendant's mental health and cognitive functioning throughout life, as well as that of his family and caretakers, is essential information during the sentencing phase and also often pertains to merits phase issues. ABA guidelines explaining that neurological and psychiatric impairment combined with a history of physical and sexual abuse are common amongst persons on death row, and how this can impact several aspects of the case other than sentencing. Like other mitigating circumstances, merely identifying mental health diagnoses is insufficient to tell the client's story. Reliable mental health assessments depend on extensive life history information, including information about family and genetic histories. Moreover, in addition to basing evaluations on reliable and complete life history information, experts must be selected on the basis of specified red flags in the client's history and each expert's specialty. They cannot be generalized forensic practitioners brought in to look for any variety of potential diagnoses. Experts that may be necessary in a capital case come from a variety of specialties and may include medical doctors, psychologists, psychiatrists, neuropsychologists, neuropsychiatrists, endocrinologists, toxicologists, pharmacologists, and various PhDs, such as PhDs in childhood development or early development education. Within each of those professions, there are a host of specialties that must be tailored to the case, such as childhood abandonment and neglect, complex trauma, intellectual disability, traumatic brain injuries, fetal alcohol syndrome, in utero exposure to substances, effects of specific drugs or substances in combination with existing disorders or mental illnesses, and so on. In light of the fact that experts with different specialties will be necessary for each case, decades of case law confirms that it's simply ineffective assistance for counsel to permit a mental health assessment of the client to occur before having made a reasoned decision about the purpose of the examination and having provided the examiner with the data necessary to reach a professionally competent conclusion respecting the question presented. Experts are often essential to telling the client's story in a way that answers the all-important why question. There are numerous examples of capital case reversals because counsel failed to complete the social history investigation, even when competent experts have been hired because the evaluations resulted in inaccurate and or incomplete information presented to the sentencer. Do you see what she's doing there? Basically, if you don't approve this, hi Tara, if you don't approve this, this wouldn't be the first time. This wouldn't be the first time that it would get turned over, even if you convict him. Oh, congratulations, Jenna Gypsy. Definitely. Well, it's because she's going through a lot of case law specifics explanation, and it's not all pertaining to like Bryan specifically or the trial versus very general case law and stuff. This is case law. So therefore, the investigation into the individual's life history must be completed before counsel can know the full spectrum of necessary experts for the penalty phase. This is essential because the accuracy of the evaluation relies on precise background information, and counsel must identify the appropriate type of expert to engage. Forensic neuropsychologist George Woods emphasizes that the accuracy of a diagnosis is contingent on the social history, and cognitive deficits are likely to be overlooked if a comprehensive social history is not complete. This is because, quote, cognitive deficits often present as a series of defective links in an action, particularly in new, novel, or stressful circumstances, rather than discrete symptoms like hallucinations or delusions. The ABA guidelines highlight the complexity of this process and acknowledge that creating a competent and reliable mental health evaluation consistent with prevailing standards of practice is a time-consuming and expensive process. So counsel requires additional time to fulfill the minimum requirements described above. Oh, nice wording. Hi, Justin. Thanks, FOS. Thank you for reading this. I know it's not fun. Let me be clear. It is. But when it's a lot of reading and I don't have shade, believe it or not, alternating really helps because you get a break. It becomes a little redundant, even though the case law is super important and it's great to be able to refer back to other cases where the same arguments were used and what the judge decided on. But yes, with this, I kind of want to know, tell me how this is going to affect Bryan, but I understand like she's going through, this is necessary, but thank you. Mm-hmm. Thank you, Mallory. So it says counsel cannot review all of the relevant discovery and complete the necessary investigations prior to trial. Bitch, sorry. Miss Taylor. He will not testify. Mark my words, Depley. He will, not even a chance in my mind. Not even considering it. But what have you been doing, ma'am? You wait. Right. We're so close. We're what, 80-something days away? As counsel explained in recent filings and an oral argument, which are hereby incorporated in full for brevity's sake, it is impossible for the defense team to review the necessary and relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case to pursue all necessary investigations arising from review of the discovery, including into alternative perpetrators, and to address the myriad issues that continue to arise from the state's failure to fully abide by this court's discovery and expert disclosure deadlines. Oh, shots fired. Counsel requested that this court alleviate these problems by precluding the death penalty as a possibility, freeing up counsel's time to focus only on the merits phase preparation and removing the heightened standard of reliability that governs death penalty proceedings. It's a nice move, though. Hi, Thievie. Because the court denied that motion, counsel is obligated to seek a continuance to continue reviewing discovery, complete investigations relating to the merits phase, including into alternative perpetrators, and complete investigation into red flags that have arisen in the life history investigation. I'm sorry, the red flags. So is your client guilty? In the red flags in Bryan's life history? I don't understand. So you're either going to, argue that he didn't do this, but if he does get found guilty and he goes up for the death penalty, let's go through the red flags of this, right? How there was always something wrong with him and he needed help at an early age. Courts have recognized that the prosecution has an advantage in the investigation and discovery issues because of the resources at their disposal. And this is particularly true here, where the prosecution has had the assistance of the federal government. The prosecution has not provided defense counsel with a list of potentially exculpatory or impeaching evidence within the vast tranches of discovery in this case, and the court declined to order them to do so. Oh, don't you take jabs at Hitler? During oral argument on that motion, the court identified a practical problem with relying on prosecutors to identify and list all... Oh, wait, I'm sorry. Hold on. Wait, I think this is about case law. Never mind. Wait, I don't know, actually. During oral argument on that motion, the court identified a practical problem with relying on prosecutors to identify and list all exculpatory and impeaching information. Prosecutors are advocates of their side and see the case through the lens of trying to secure a conviction. Thus, what may appear exculpatory to a Thus, what may appear exculpatory to a defense attorney or lead to the discovery of exculpatory evidence through additional investigation may appear only tangentially relevant to a prosecutor. Given the heightened standards of due process afforded to a capitally accused defendant, it is imperative that counsel has time to review the relevant discovery and conduct any necessary follow-up investigations. Have you not had that time? Seriously, though, like, you have had time. Why the hell would you take on another death penalty case when everything you just listed about how in depth it goes in for capital punishment, yet you took on another capital punishment after? That makes no sense. Cutting off this review before counsel can complete it would significantly prejudice Mr. Kohberger. The state's case is circumstantial. Most cases are. Mr. Kohberger was not identified as a person of interest until weeks after the crime. And after he was identified, law enforcement ceased investigating all other possibilities. While counsel can explain this in trial, every experienced trial lawyer knows that trials are essentially story battles, high-stake duels where the prosecution and defense each tell competing narratives about the same set of events. Ultimately, the jury decides which story feels more true and more coherent. Even though the burden of proof rests with the prosecution and the defense bears no burden at all, humans are driven by narratives. That reality forces the defense to counteract the state's narrative with another compelling story. The jury might speculate that if this defendant did not do it, there should be at least some evidence suggesting that someone else did. And it is especially incumbent on counsel to become aware of all existing evidence, because alternate perpetrator evidence may be deemed inadmissible under Idaho law if it, quote, merely tends to mislead the jury that another person committed this crime. Thus, defense counsel's review of the discovery is not merely checking a box. It goes to the very heart of the ability to prepare and present a defense. Reviewing and integrating all of the evidence in order to tell the jury a coherent counter-narrative is essential to defending Mr. Kohberger's life. The state and its superior investigatory apparatus has spent years honing in on one specific story, that of Mr. Kohberger's guilt, and ignoring all other possibilities. Defense counsel has a bigger job in not only viewing their case of guilt, but figuring out what the state missed and exploring other alternative possibilities. The inability to review the discovery and incorporate all of the other information into a cohesive defense prior to trial would nearly guarantee that counsel cannot mount an effective defense on Mr. Kohberger's behalf. Because his life is on the line and due process must be given in its highest regard, the court should grant counsel the time necessary to ensure a fair trial. Pause. The burden of proof is on the state. So, Anne, I understand what she's saying, but no, your task does not have to be sitting there and going through the entire case of the state and then making your own case for someone else. If that doesn't tell you she is desperately looking for evidence she could use, anything she could use to create that reasonable doubt versus standing on the fact that state should not be able to prove their case if he is innocent. You know what I mean? You shouldn't have to be going and trying to search to not only counteract all of the evidence that the state is going to present against Bryan, but to search for anything you could use to point to someone else. If your client is innocent, the evidence should not be pointing towards him. And the state won't be able to prove it beyond a reasonable doubt because it didn't happen according to you. Exactly. You don't even need to put on a defense technically. So B, the life history investigation is ongoing and requires additional time and expert assistance. And this is about the ASD diagnosis. As more fully discussed in the ex parte supplement to this motion, the life history investigation remains ongoing. Counsel is reviewing and digesting significant new records that have been received in the past couple of months, addressing ongoing barriers to receiving important life history records and continuing to build rapport with several key life history witnesses. As explained in the accompanying ex parte filing, the investigation to date has revealed red flags for a number of mitigating themes and issues, and counsel must fully investigate these avenues before making strategic decisions related to sentencing. As discussion in that section, only after a more thorough life history investigation will counsel know the range of experts that will be necessary to contextualize Mr. Kohberger's life story. And Mr. Kohberger is entitled to maintain the confidentiality of the defense team's ongoing investigation. So a continuance is also necessary to investigate and remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline NBC special and a forthcoming book. Which again, you don't need to investigate that. You don't need to investigate that, Anne. Your job from the defense team is not to investigate that. A special prosecutor's job will be to investigate that. And dependent on what they find, will be a completely separate case. This case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9, 2025, just weeks before this capital trial is set to begin, Dateline NBC aired a 2-hour episode about this case titled The Terrible Night on King Road. The program includes details and materials, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The show repeatedly emphasizes the non-public nature of this information, stating it was obtained from unnamed sources who are close to the investigation, and that the materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. So it's legit. AKA, it's legit, but the jurors will never see it. The leaked materials appear carefully curated to promote a narrative of guilt. As this court acknowledged in its May 15, 2025 document and records hold order, the source of the leak is most likely someone currently or formerly associated with law enforcement or the prosecution team. If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence, particularly those who may be called as witnesses. I don't disagree with that. The identity of those involved, their motives, and any efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. That's a good point. I don't disagree with that, but that really, I guess I could understand you need to push it off until a special prosecutor possibly is able to determine the source, but I don't know. She's accusing them, but I'm looking at the defense. Yeah. Hey, Sarah. The apparent leak is not only an egregious violation of the court's non-dissemination order, It enabled Dateline to gild rampant speculation with a veneer of credibility. When purportedly exclusive information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the investigation, it carries a heightened aura of credibility and secrecy that can deeply influence public perception. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, leaks framed as exclusives are perceived as uncensored truths that the public was not meant to see. This insider framing enhances the material's persuasive power, suggesting that it is both authentic and revealing of the case's hidden realities. Right, a King Skull, and that's what I said before. Like, in reality, we would usually already have all this information. The episode includes things such as repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motivation, dramatic reenactments and animations depicting the alleged crime created by the show's producer without basis in its evidentiary record, emotional interviews with individuals connected to the alleged victims. Alleged victims? Alleged victims? Oh, I don't like that. So, emotional interviews with individuals connected to the alleged victims, accompanied by evocative music, photos, and videos designed to elicit strong emotional responses. The broadcast repeatedly bolstered its speculative claims through the use of so-called expert commentary, including individuals identified as law enforcement professionals and academics. These commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court, while the program repeatedly emphasized their training, research, and years of experience to lend undue credibility to their conjecture. This type of testimonial mimicry improperly mirrors expert witness testimony in a trial setting without the safeguard of cross-examination or evidentiary standards, effectively presenting the public with a one-sided, unvetted narrative that shapes juror perception before any admissible evidence has been presented. Okay, pause. Hi, Coffee and Skeletons. Yeah, I didn't like the alleged victims at all. While the program occasionally inserts disclaimers such as, "We don't know what happened," these brief caveats do little to mitigate the cumulative impact of an extended narrative constructed through selective imagery, emotionally charged reenactments, and detailed speculative descriptions of the crime. When viewers are presented with a cohesive, visually reinforced sequence of events, especially when paired with commentary from individuals styled as experts, the overall presentation fosters a sense of authenticity and truthfulness that is difficult for viewers to disregard. An occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on prejudicial perception, and most viewers will leave with the impression that they have seen a reliable reconstruction of events. The Dateline special, which aired just weeks before the trial date, will not even be the last pretrial media bombshell. Best-selling crime author James Patterson has written a book about the murders titled The Idaho 4, An American Tragedy, scheduled for release on July 14, 2025, just 16 days before jury selection is slated to begin on Amazon. The blurb for the book describes Mr. Kohberger as a, quote, brilliant grad student, loner, apparent incel, and explicitly tells the reader, quote, now you are the jury. The evidence is in. The publisher boasts of unmatched access to the investigation, including interviews with local law enforcement. This suggests that the apparent Dateline leak was not the only violation of this court's non-dissemination order. The 6th and 14th Amendments guarantee the right to a fair trial by an impartial jury. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial effects of such inflammatory pretrial publicity occurring so close to the current trial date. So that's case law. The Supreme Court has likely recognized that the passage of time, sorry, I had a hiccup. The passage of time can significantly reduce the taint of media exposure. Whoa, come on. Holding in Patton versus Yount that even in a case involving extensive coverage of a confession, the delay between media saturation and trial reduced its prejudicial impact. The court has recognized that while pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, the trial judge has a major responsibility. The measures a judge takes or fails to take to mitigate the effects of pretrial publicity may well determine whether the defendant receives a trial consistent within the requirements of due process. The timing of the trial is a key factor in assuring juror impartiality, as emotional intensity and memory of prejudicial material tend to fade over time. So let's just wait for them to forget it. Sorry, I was trying to stop my hiccups. Okay. Hey, so there's that. Social science research supports this position. A comprehensive meta-analysis found that pretrial publicity significantly increases the likelihood of conviction, but that the effect is diminished when there is a temporal delay between media exposure and trial. In sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupportive theories through self-styled expert commentary, all timed to air just weeks before the trial, when juror impressions are most vulnerable and Vordar least equipped to neutralize such deep-seated bias. The forthcoming book by James Patterson, which will arrive in the hands of potential jurors just 2 weeks before voir dire begins, promises to set off a new round of inflammatory, negative coverage and to deepen the pervasive bias against Mr. Kohberger on the eve of trial. The court has already acknowledged that the Dateline special exposes a likely violation of the non-dissemination order, and Mr. Patterson's purported unmatched access to sources, including local law enforcement, suggests that multiple unauthorized disclosures have occurred. Depending on the results of the investigation into the leaks, a continuance may be inadequate. Once the source of the leaks are identified and the full extent of misconduct revealed, the violations could warrant remedies more serious than delay. At the very least, however, a continuance is essential to allow the extremely prejudicial impact to partially subside, and to give the court and the defense time to fully investigate and address the scope of the violations. Only then can the conditions necessary for selecting an impartial jury and ensuring a fair trial under the 6th and 14th Amendments can be meaningfully restored. Oh, God. We're almost there, guys. FOMO. Reversal is more likely than not in any case resulting in a death sentence. Okay, good night. Feel better, Mom Silk. Statistically, almost 2/3 of death penalty cases are eventually overturned due to errors, often many years or even decades after the initial conviction. A frequent cause is reversal of ineffectiveness grounds due to the lack of an exhaustive investigation and complete presentation to the sentencer. Hundreds of cases could serve as examples, but for brevity, the following are examples from the U.S. Supreme Court. So let me see. Okay. Cases resulting in the death penalty undergo a unique, extensive appellate and post-conviction process through both the state and federal courts, and this process generally lasts decades. It is not uncommon that cases are reversed 5, 10, or even 20 years into the future, resulting in both new trial or sentencing proceedings in the district court, and then beginning anew the appellate process. Mr. Kohberger deserves a fair trial from the outset to prevent an arbitrary or wrongful conviction and potential death sentence. These cases underscore the critical importance of thorough investigation before trial. This diligence is essential to avoid the costly and time-consuming process of reversing a conviction and death sentence years or even decades later. A continuance is reasonable and necessary under the circumstances. While there is no mechanical test for determining whether a continuance should be granted, a trial court cannot deny a continuance based on myopic insistence upon expeditiousness in the face of a justifiable request for delay. In determining whether denial of a continuance request resulted in a violation of due process, the reviewing court looks to the circumstances of the case, particularly the reasons presented to the trial judge at the time the request was denied. This request is not made lightly. Defense counsel has worked around the clock actively preparing for trial since appointment to this case, filed all motions in a timely manner, complied with expert disclosure deadlines, and had expected to proceed on schedule. However, it has become clear that without additional time, the defense cannot complete review of the necessary discovery, meaningfully respond to all of the state's amended expert disclosures, and incorporate the information into an effective defense and finish critical sentencing phase investigations. While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. And because of the majority of cases ending in the death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. A continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts, not on a forced haste. Whew. Did it. Okay. What are your guys' thoughts? Natasha. Give her 2 extra days. Oh my goodness, Lisa. What makes you say that, Tanel? I'm aggravated. She's going to keep begging for more time no matter how much they give her. Yeah. I think I don't fault her. Yeah, Morale. I don't fault her. You think so, Kristen? She's doing... I know, Natasha. She's doing what she should be. But again, I don't like, you technically don't have to put on a defense. It is the state's burden to make the case. if I am looking at it through the lens of believing he is innocent, nothing should line up perfectly. You shouldn't have to be going through looking to create a whole case against someone. Now, when I say that, obviously alternate perpetrators can be used, but I feel like it's usually apparent from the start. Maybe not from the start, but not so much, oh, we're just like she says, on the eve of trial, all of a sudden you're working so hard to figure out who can we blame. She did, Lisa. She had a lot of time. She had a lot of time. And now when I say that, like, I know how massive Discovery is, but you have to also understand a lot of that is not relevant. And I understand everything's relevant. Yes, I understand that. But when they get footage, they have to get all of it. You know what I mean? And really, it's like the pertinent time period is very minimal. So there's a lot that really is not, you could be having paralegals and stuff going through it for you. Yeah, it would be up to her. If they are going with the alternate, like an alternate perpetrator, it's up to her to make her case. But just like the alibi, she has to hit standards. She has to meet certain standards. Oh, without a doubt, Sprinkled Donut. I don't believe for 1 second Anne doesn't know he's guilty. Exactly. But she's saying she wants to look at everything. Right, which exactly, that's setting it up for fail. Like, don't tell me. I understand what she's saying as far as, well, they won't know what to look for. Okay, if you want them to go through the 24 hours of footage and you say, hey, anytime you see a car, mark down the timestamp. Anytime you see this car, and then bam, it just cut it down halfway. And then you could go and look, but come on. It's just not, it's too close. Here's the problem. It's too close to trial. If you didn't have time, just like Hitler said, when I checked in on you months ago, you told me everything was on track, and you have since taken on another death penalty case. You can't all of a sudden turn around now on the eve of trial and say, I can't get through this. Exactly, Crocheting. So she's doing both. She's making like a dual argument, which is more obvious in my opinion. Not so much that I have so much discovery to go through, but also let me figure out, now that I got this ASD diagnosis, of how I could tie this in to past events. Yeah, Natasha, and he offered to give her as much staff as she needed. Oh, absolutely, Sarah. Listen, everyone deserves a fair trial. Everyone deserves a good defense. And there have absolutely been a concerning amount of times where a defendant is innocent. And that's terrifying. But this is a very high profile case. Everything is under a microscope. If he didn't do it, it should be apparent because the pieces won't all fit. Yeah, accomplice. So again, everything in me says no because we're too close to it, and the families had to book this, plan this, the money for it, everything. It's 3 months. You have to go get up and leave your state. 3 months. No work, finding an Airbnb, hotel, whatever it may be, and the money. But, like I said before, when the defense requests a continuance and you don't at least grant one, it can be used to appeal. Because then the defense can turn around and say everything that Anne argued in here. I didn't have enough time. I asked for a continuance. I wasn't granted ineffective counsel. If he approved one continuance and we were on to the second continuance, I do. I think she was setting it up, Lisa, and she set the stage already and we felt it was coming. But this was just her opportunity to combine the two. So I'm terrified. I don't want to say I'm terrified, but Judge Hippler may have to prevent an issue down the line. Now, he may push it out for like 6 weeks. Who knows? I'll give you a continuance, not a long continuance, so that way he's still granted the continuance. Yes, Samantha. But if he doesn't grant this, all issues of ineffective counsel can be raised. So I know Judge Hippler has been working his ass off, hi Shazzy, to make sure this trial stays on time. He's been doing everything for it to go as smoothly as possible, but his hands might be tied and he may need to grant it. It's a good point, Angel. Yeah. No, it wouldn't be a mistrial. So that person can be prosecuted, but it's just violating and being in contempt of court. Now, if that person, like Anne was saying, if it's defense side, okay, let's say it's state side, and that person happens to be very head up in the investigation, and that is a witness, a heavily relied on witness, and then it's found out, that could be an issue because all the testimony now goes to the credibility of the witness, right? And the credibility of the witness violated a non-dissemination order. That could be an argument, but we're not there yet. But Anne is making the argument, that is a good point. If it does come out that it's someone close up in the investigation who may be a potential witness and I don't know it, and it comes out down the line, this detective was the leak. Well, then what happened to all the testimony? Well, she said neat noodle all the way at the top. Hold on. I say ineffective because, God, geez, what page was it on? for the appellate and post-conviction review. So counsel must thoroughly investigate and challenge every minute piece of this evidence. The defense lawyer's obligations, include XYZ. Where was it? Hold on. Counsel's duty to provide effective assistance of counsel in accordance with prevailing professional norms. So, due to the extraordinary nature of the penalty at every stage, counsel must make extraordinary efforts on this behalf. Where was it specifically, though? Hold on. Goes to the effective assistance of counsel. Right, both rights to a meaningful opportunity to present a complete defense. Defendants are entitled to expert assistance, right? There were too many pages, man. Where was it? So, Mr. Kohberger's constitutional rights as described above, counsel must at least meet the minimum professional obligations for counsel on a capital case as outlined by the ABA guidelines. High quality legal representation for all persons facing the impossible imposition or execution of a death sentence by any jurisdiction. So they recognize every task ordinarily performed in the representation of criminal defendant is more difficult and time consuming when the defendant is facing execution. So they must make extraordinary efforts, and they must meet the merits phase. Let me see. There was a specific paragraph that I'm looking for. Counsel is then responsible for identifying and considering all legal claims. No. I'm going to find it. Hold on. Oh my good Lord. Where the fuck did it go? Okay. So there are numerous examples of capital case reversals because counsel failed to complete the social history investigation even when the competent experts have been hired, because the evaluations resulted are inaccurate or incomplete information presented to the sentencer. So holding counsel ineffective where they consulted 4 experts, including a medical doctor, a psychologist, psychiatrist, but they failed to consult a neurologist or toxologist who could have explained the neurological effects of defendants' exposures to pesticides. So, overturning a conviction and death sentence because counsel was ineffective for failing to provide the hired mental health expert with a social history, necessary information to conduct a proper evaluation, and the expert erroneously concluded that the defendant suffered no major mental illness, when in fact the defendant suffered from mild retardation, organic brain damage, and schizoid personality disorder. Conviction reversed because this information would have also been relevant to a diminished capacity defense. Therefore, the investigator, okay, blah, blah, blah. Where'd the last thing go? So counsel requires the additional time to fulfill the minimum requirements, and counsel cannot review all of the relevant discovery. So, as counsel stated in an oral argument, it's impossible for the defense team to review the necessary and relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case to pursue all necessary investigations, blah, 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 right? So counsel requested that this court alleviate these problems by precluding the death penalty. The court denied it. So they're seeking a continuance, including into investigations for the alternative perpetrator. And courts have recognized the prosecution has an advantage. Okay. Where is it? So thus what may appear exculpatory. So cutting off this review before counsel can complete. Okay. Cutting off this review before counsel can complete it would significantly prejudice Mr. Kohberger. Mr. Kohberger, okay, whatever. So while counsel can explain this in trial, every experienced trial lawyer knows that trials are essentially story battles, right? And it is especially incumbent on counsel to become aware of all existing evidence. And then defense counsel's review of discovery is not merely checking a box, right? Reviewing and pertaining everything. Defense counsel has a bigger job in not only reviewing their case for guilt, but figuring out what the state missed and exploring other alternative possibilities. The inability to review the discovery and incorporate all of the information into a cohesive defense prior to trial would nearly guarantee that counsel cannot mount an effective defense on Mr. Kohberger's behalf. Because his life is on the line and due process must be given its highest regard, the court should grant counsel the time to ensure a fair trial. And they were explaining down the line, all of these issues can be brought up, and they could turn around and say they were not able to get him effective counsel. And they're going to say, we requested additional time and we were not granted it. But if you granted that additional time, I would have been able to do it. So she detailed all of it. Hi, Jess Moore. So they'll try to go and get it overturned. Yeah. Well, we need defense attorneys too. They'll try to go and get it overturned because they were not able to be effective. They're asking for more time. They're not able to get through it. And she's saying majority of these cases do, a good portion of these cases do get overturned anyway. So you may as well get it right the first time. Save the public the money. Well, I actually understand her argument. I do understand her argument. If you don't grant this continuance, and I'm telling you as his counsel, I cannot be effective and get all of this done. By you not granting that continuance, you're essentially saying, I can't do my job. And that's not fair for the defendant. And that could be absolutely an issue potentially down the line if there is a conviction. She would, Hazel Eyes, yeah. So it all circled back around to her ineffective counsel argument. But she's the one raising it. She's the one saying, Not him, not Kohberger saying, I didn't have effective counsel. She's saying, if you don't give me the time, I cannot do my job. I cannot be effective counsel. She arguing for a continuance is doing her job, but if he doesn't at least grant one, later on down the line is what I'm saying, is it can be used to make an argument to potentially get it overturned because that motion for continuance wasn't granted. That's why a lot of times they will always grant at least one continuance. Back with Judge, I remember just waiving the right to a speedy trial. I don't remember the trial itself. It was supposed to be in October. And then they waived the speedy trial. I don't remember the trial ever getting a continuance itself. Hearings did, unless I'm wrong, and please correct me if I am. Correct, Morale. And it shows she tried. It shows she stated, it is very well documented within this motion, I have not been able to get through the discovery. I have not been able to get through the life history. I am not able to do all of my tasks, especially in a capital punishment case. I'm asking you to take the death penalty off the table so I could focus on phase one, right? I could focus on just the actual trial itself, but you denied that. So now I need to ask for a continuance because there's no possible way I could do my job as his counsel and get through all of this. And that way, if he doesn't grant it, it can be used. Donald, it's a losing battle either way for him. If he doesn't grant it, it runs the risk of it being later used. If he does grant it, it really screws the families. It shouldn't FOS, but there are definitely a lot of preparations, and she cited all of them that it goes into a death penalty case. That's why you have to have only specific lawyers who are death penalty qualified can take them on. Well, and I love, Betsy, that Judge Hippler confronted her about that. He deserves the best defense. Everyone deserves the best defense. And the way I see it is, if you're guilty, the evidence will show that. Yeah, I'm not mad at her. There have been like 2 times where I feel like she's taken it too far. But overall, she's doing her job, you know? Thank you, Sarah. I really am torn as far as what I think is going to happen. I know Judge Hippler does not want to push this out, but I think there's a good chance he will do a short continuance where it's not going to be like a year where it will do that to the family, but it will still grant the continuance, give a little. I see him asking her, how long do you need? I'll give you 20 what do you need? You know? But she's not going to be she's not going to be happy. She's going to ask for another year, I feel like. I think he will harlot. I know he does not want to. I know he does not want. Everyone who's watched the hearings know he does not want to. But I really think to cover the tracks and make sure it's not an issue potentially down the line, I think he's going to grant a short continuance. His hands are tied. It's not, it's not his fault. It's a lose-lose either way. Well, another year, as long as it seems it's not that long in the eyes of the court, and as far as getting through discovery like that. She's really trying to twist his arm to drop the death penalty. I just don't like, I saw someone made a post. Good job, all of you guilt burgers. Now look what you did. First of all, even for the people who think Bryan is likely guilty, doesn't mean that they all agree that there was a leak, holy shit. Hey, Anne. I'm behind, but want to say let the judge extend the sentencing phase of the trial, give her 3 weeks after the jury rules guilty or not. I can't see Hippler going beyond 6 months, aware of the families did have to plan this and take off. Like, imagine picking up and going to another state for 3 months. You have to make accommodations. Oh, that's what I wanted to share. So Xana's mom has a GoFundMe was made for her. To help with expenses to go to trial. All of the families had, basically. And as far as I know, she's doing very well. She's sober, working, she's doing good. So I'm going to drop a link to that for anybody who would like to contribute. But with that being said, it's your choice, and I get very weird with anything to do with like funds or money. Just understand there's always a risk. I'm not going to verify anything like that. I can't, I don't know. So just do it if you want to do it. But there's always a chance with anything with funds. Just know that. But I'm going to drop the link to it for anybody who wants to help. Natasha, Xana's mom, basically all of the families have had a GoFundMe to help pay for the travel expenses to get to trial. The cost to travel there, the cost to pay for like an Airbnb for 3 months, food, things like that. Um, and so this is Xana Kernodle's. I'm not saying that there's anything wrong with it. I'm just saying I don't usually like to drop links to anything because I've seen shady shit before. And again, I'm not putting that on this GoFundMe. I'm just saying, oh man, is that too long of a link? I'm not putting my name across it, but I'm going to share it out. It's your choice if you want to share it or not. Why does it get so big like that? Hold on. How can I get a smaller link? Oh, share, copy link. Okay, here we go. Sorry. Oh, it did, Harlot? Oh, okay. Well, then here it is. So I'll read to you what it shows. So it says, and look at this photo of Ethan and Xana, okay? It says, help Kara be at the trial. Justice for the Idaho 4. There's $3,422 raised out of the $6,000 goal. And it shows, my name is Lori Scott. This isn't about or for me. This is for Xana Kernodle. She is the mother of Xana. She was a student at the University of Idaho, and on the 13th of November 2022, her and her boyfriend Ethan Chapin, roommates Madison Mogen and KayleeGoncalves, were brutally taken from family and friends. There is a trial for the person arrested for this crime. The trial is in August, and there is no way she can afford to be there without help. She has overcome so much and just wants to be there to know the correct justice is served. No mother should have to deal with this, but to be able to not afford to be at trial is unthinkable. She has friends in her church, but the cost of everyday living has to be considered as well. Please help this mom be able to honor her daughter and friends by being there for whatever happens at this trial. I spoke with her today and she has been stressing this. Let's help her not have to. Xana was a college student who loves her boyfriend, her sister Jasmine, her little brother Elijah, her mom and dad. Just a young woman who is well on her way to being a successful woman with a smile that would light the darkest night. These young people would have continued to make the world a better place. The travel expenses, food, and having to miss work is something most of us couldn't do without help. Please put yourself in Kara's shoes for one moment and give what you can. Many people giving small amounts will get her there. Thank you and God bless everyone. Please keep her in your prayers. She has to face this every day and should not have to face the possibility of not being at trial. So when it's not directly in a person's name, I get a little nervous because if anyone goes back, knows that there was a situation with another creator who did this for Kara and it completely was wrong. It was bad. So that's why I say I get nervous anytime to share funds, but that's why I'm saying, hey, this is it. You could see it. I can't tell you 100% everything is good with it, but that doesn't mean that that doesn't mean anything's bad with it. I'm just saying, don't say, well, Melissa, you said that. I don't freaking know. I'm just sharing it out. And if you feel compelled to donate, please do. Why can't I? Why can't I zoom out? Where'd the photos go? Oh. Oh. Oh, look at that. Why can't I zoom in? Look at that photo of little Xana. Thank you, Sarah, for the super sticker. Thank you. You remember the stuff, Leon? Yeah. If you can't tell, even when I talk about it, I tend to jam up because I get uncomfortable. But thank you, Sarah. I just don't want anyone to be like, well, I trusted you, Melissa, because you shared it out. I don't ever know. I want to share it out, but like I just don't want to be held responsible in case something like that other situation went down. Look at the little Xana. So yeah, with Judge Hippler, he's in a lose-lose situation right now, unfortunately. But all right, I guess we'll see what the next live brings. I'm so sad that Shay wasn't here, but we've got a lot to go over. I think it's going to take probably a week before we hear back regarding a decision. This is a big decision, but I think he's forced to grant it. Unfortunately, that's gotta be so hard. But I guess we'll see. We'll be back in next week, and we'll do, because I'm not going to be live again until Sunday. But we'll be back next week, and we'll continue going down this rabbit hole. Maybe we'll have an answer by the time I'm back. So thank you all so much for hanging out. Thank you, mods. You guys are amazing. Yes, they do, Samantha. Not even like, yeah, I guess you could call it scammers too, but then just pieces of poop. Pieces of poop, man. Um, but just prayers for these families. And I will talk to you all soon.